Good morning, everyone. I think we're going to wait just another moment to allow people to get in from the waiting room. And it looks like we're all in. So good morning. Welcome to the March 27th, where did March go? Zoom meeting. So we're going to go through the usual Zoom housekeeping tips. So if you are wanting to have your video on, video off, mute and unmute, that's usually at the bottom of your screen. We ask that people keep muted during the presentation so that it's easier for everyone to hear. If you have a question or want some clarification, feel free to unmute yourself to ask the question or put it in the chat. I know during the presentation, Chelsea will be monitoring the chat, and then as we have time, Ken and I will also pop in there to take a look at it. So again, the general disclaimer, this is not legal advice. This is general information that we think may be applicable to most communities in our state. So if you need legal advice regarding something, or you send us an email with citations to your governing documents, multiple citations to statute, that's probably legal advice. We'll do our best to answer as generally as possible, but you really need to consult with your association attorney. Please keep in mind that the chat function is for asking for clarification or asking questions if we have time. It's not for commentary like on the CAI message boards. Most people are fantastic about doing this, and we really appreciate that. So uCioA for All did pass. We're going to cover this probably for the next few weeks. So it's still with the governor waiting to be signed. The only way this statute will not become effective is if the governor vetoes it. If he fails to sign it, it will still become effective. We believe he will sign it, so it will take effect on January 1st, 2028. You can adopt uCioA earlier if you wish. You can choose to revise your documents now to make sure that you're in compliance with uCioA before it comes into effect. You can also wait. It's really up to you and your association. Since uCioA came into effect July 1st of 2018, the restatements and amendments that we've done for our clients are uCioA compliant. So they'll require very few, if any, changes as the statute becomes effective. So if you have any questions, please feel free to contact your association attorney regarding what you need to do to become uCioA compliant. It's always a good idea to start complying early, so you're comfortable with what you have to do and the changes that you need to be making in your procedures between now and when uCioA becomes effective. The WSCAI Journal has an article coming out in the coming weeks about common misconceptions about the uCioA for All bill. So keep your eyes out for that if you have further questions.
I've got one comment, Jennifer.
Okay.
People do not have to revise their documents to or when uCioA takes effect. Just as no one had to revise their documents to incorporate the sections of the Condominium Act that applied to old Act condominiums, you can just let your document stay as it is. You just have to remember that if uCioA has a provision, it's going to control over your document. And so the reasons that people might rewrite their document are just to avoid confusion or make it easier to look in one place. But there's also going to be this eternal problem that uCioA is going to be continually amended. I mean, it's been amended 4 times, 5 if you count this year, since it was adopted 6 years ago. So it's not like you're going to be able to get one set of new documents and have it be permanently effective. There are always going to be changes by the legislature. Those will apply. You don't need to spend money and revise your documents if you don't want to. You just need to comply with the statute, and you can continue with your existing documents. They are still going to control to the extent they don't conflict. Thank you.
Okay. So moving on, the Corporate Transparency Act, a federal district court judge in Alabama has ruled that the Corporate Transparency Act is unconstitutional. This ruling will likely be appealed to the 11th Circuit and eventually the Supreme Court. So this just creates more uncertainty whether the CTA will become effective or is effective and what associations need to do. So we recommend taking a wait and see approach when it comes to complying with the Act's reporting requirements. So consult with your association attorney and just kind of keep an eye on this. We don't believe that anything needs to happen right now. Probably later towards the end of the summer, early fall is when things are going to really start heating up. So the last of our general housekeeping informational things, this WSCAI Annual Conference is coming up weekend of April 19th. This particular conference takes the place of Made for Managers Day and Law Day. So there are going to be vendors with booths for homeowners and managers to speak with. There will be educational opportunities. It's going to be a great event. So please feel free to go to the WSCAI website and sign up if you haven't yet. So jumping into our questions for today, and we may have time at the end. So if you have a question, please feel free to pop it in the chat. I did see a chat pop up asking if the governor signed UCIOA for all. We did cover that briefly. He has not, but even if he doesn't sign it, it will still become effective. The only way it doesn't become effective is if he vetoes it. So our first question, at the March 6th webinar, Valerie says a candidate doesn't need to get a quorum's worth of votes to win, but rather the person who gets the majority of votes wins in an election. Is that the same as plurality voting? The answer is yes. Plurality voting is defined as a voting system where the individual with the most votes, but not a majority, wins. And remember that your particular governing documents can have different requirements. So how your elections are run are very specific and very dependent on your governing documents. If you have questions on how this is supposed to happen, please contact your association attorney. The general rule is that if you have a quorum, the individuals who receive the most votes cast are elected. This often does mean that they receive a majority of the votes cast, but again, this is really dependent on your governing documents. Please contact an association attorney. Ken, did you have anything to add to that?
The only thing I would offer is that if you have fewer candidates than positions, that we do take the position that the candidates need to get a majority of the votes cast to be elected. You don't just get stuck on the board because nobody else wants to be there if the membership is not willing to let you serve. So we did have a community for at least 5 years. They had elections. No one wanted to be on the board because of a difficult owner. He was the only one who was willing to run for the board. And so they would have an election every year just on whether or not to let him serve on the board. And if he couldn't get a majority of the votes to say, yes, he could serve on the board, then our opinion was that he couldn't be on the board. So there can be interesting exceptions to how the voting process works. If you've got something screwy going on, then we recommend you get a parliamentarian or an attorney to help you with it. So, second question, how long does a lien remain on a home in the state of Washington? Once the lien is placed on a home, how long before you have to foreclose? I've heard the liens fall off if not foreclosed. So the answer depends a little bit on the kind of lien. we're assuming you're talking about liens placed by the association on a unit or lot. There are IRS tax liens, which have different rules, and there are contractor liens for material and services placed on properties, which have different rules. Contractor liens do expire if they're not pursued with a lawsuit within 8 months. But the association liens generally have no expiration date. But the expiration date doesn't mean that the ability to collect money won't go away. There are statutes of limitations, 3 years under the condominium statutes, 6 years under the HOA statutes and WUCIOA. And if debts become older than those statute of limitations, they will not be collectible, even if a lien is existing on the property. So we know we have clients that just place a lien and assume they will get paid when the unit sells, whether it's 2 years or 10 years. And that may or may not be correct because it really depends on how old the specific debt is. And it may also depend on how payments are applied. If you're always applying payments to the oldest debt, then you get some relief with regards to the statute of limitations. But there are some governing documents which specify that the payments have to be applied first to things like late fees, interest, and attorney's fees, which means that you may never get that old debt from 5 or 6 years ago paid under your ledger. And so those debts will fall away and be uncollectible. Did you have anything else on that, Jennifer?
Just briefly, when we were preparing ahead of time, and honestly, in general practice in our office, we will get emails from title companies or escrow agents regarding liens on the units or lots. And we have to do the research to see what how the lien was. A lien remains on title until it is released by recording a release. But just because a lien exists, as Ken said, doesn't mean any money on that lien is collectible. So if you have questions, please contact your association attorney.
Yeah, the Valerie's comment when she was talking with us is that title companies want to see lien releases on every lien which has been recorded on the property, regardless of whether it has a collectible amount and regardless of how old it is. So occasionally we get requests to release liens that are 8, 10, 12 years old just to satisfy the title company. And typically the association ends up having to do it.
Well, and pay for it, given recording fees keep increasing. Moving on to the next question. For self-managed associations that were never incorporated with the Secretary of State, do they need to comply with current state statutes? Specifically, the Self-Managed Association wrote their own declaration back in 1980. They were worried about the cost of being incorporated and updating their governing documents. So the answer is statute always overrides governing documents unless the statute specifically says that the governing document can say something different. So just as a general rule, statute always overrides governing documents. So unincorporated associations exist for many old act condos and HOAs. The law still applies to these associations from your current statutes. You don't just get to rely on the corporation statutes to fill in the gaps. So when WUCIOA takes effect on January 1st of 2028, all associations are going to be required to be incorporated. We strongly recommend that to all of our clients that they be incorporated to enjoy the benefits of the corporate umbrella. What that means is that instead of every single individual owner being joint and severally responsible for association issues or association claims, the corporation as an entity is responsible. Unincorporated associations, it's extremely easy to become incorporated. Statute requires that all community associations be nonprofit corporations We do these in our office routinely. They are extremely simple to do. Just as an example, we offer a flat fee of $200 to draft articles of incorporation and serve as the association's registered agent. The Secretary of State fees for the filing are not included in the flat fee, but they're generally $100 or less. And then once incorporated, you need to renew your corporate status every year. We offer a flat fee of $100 to do this. It's simple, easy. There's honestly no reason why an association should not be incorporated, and soon, if it isn't already required under your governing documents, you will be required to do so. So moving on from the Secretary of State and incorporation to the declaration part of this question. Associations are formed when the declarant or developer records the declaration and survey map and plans or plat maps depending on the type of community. If an association is using a document as a declaration that was not voted on according to the recorded document, or the document that they're using was never recorded, that document is probably not enforceable. You need to talk with an association attorney to determine whether or not the document that you're using is enforceable and what you're doing is correct. We would need to see the documents in question to determine how they control. And a new set of documents, the declaration and bylaws, doesn't have to break the bank. We have three, just in our office, we have 3 different flat fee restatement, which is the declaration and bylaws projects with different flat fees. You need to talk with your association's attorney and see what the costs are. It's going to cost some, but it isn't going to be prohibitively expensive. So when you're talking about governing documents, this is the foundation for your association. It's not something that should be messed with lightly. So please contact your association attorney and let them know your question and have them review and give you guidance based on your actual circumstances. Ken, did you have anything to add to that?
Couple comments. One is regarding the incorporation. Associations can go to the Secretary of State website and incorporate their community without an attorney. It's not that difficult. Most of the reason people would hire us is because we serve as the registered agent for the association for a year. And that's really what our fee is for, not for filling in the form on the website. And then the second thing is that we get a lot of confusion when people name the governing documents that they mean. People will say bylaws when they mean rules and regulations. They'll say bylaws when they mean articles of incorporation. They'll say declaration when they mean rules and regulations. So when we get a question like this and someone says, well, the community adopted their own declaration, I would definitely have to see it to know what they actually adopted. Because if they adopted rules, they may have had every power to do that and they're all enforceable. If they actually did adopt a declaration with covenants and conditions which were intended to apply to the land, they may or may not apply. And in part because it is possible for there to be covenants and conditions on land which are not recorded. And those are called equitable servitudes. I think we've talked about them before. And that is where a court will find that a restriction exists on the land, even though it is not recorded. So if a community has been operating as if it had recorded CC&Rs or declarations for 40 years, there's an excellent chance that those would be enforced by a court. And so you would need to discuss that with an attorney to make sure you know what you're doing. Anything else on that, Jennifer?
No.
Okay, next question. Section 6490-445E of the WUCIOA requires that owners be given a reasonable opportunity to comment at any meeting. So the question is, does this include open meeting sections of an executive meeting? What about study sessions? Would you give an example of what is considered a reasonable opportunity to speak? limits on number of comments, restrictive time limits. So first, I want to start with this idea that many boards have that they can relabel a meeting name and not have it count as an association meeting. UCIOA was intended to be creating open and transparent governance of the community, and every board meeting and every committee meeting where a board has delegated any authority to the committee has to be open to owners, meaning that they get invited, and it has to provide an opportunity for owner comment. Now, this does not mean that the owners get to participate in the discussion at the meetings. It means that you have to, I'd say typically what we see is a period of time, and usually it's 10 or 15 minutes at the beginning or end of a meeting, where the owners are allowed to stand up and talk to the board. The board doesn't have to answer questions. The board doesn't have to have a discussion with them. You just need to let them talk so that they have the opportunity to be heard, and the board needs to listen. Okay, don't need to respond. If the owner asks for something, you can decide whether you want to provide it. If it's something new that the owner's brought up, then the board could add it to an agenda if they want to. Okay, so the language requires a reasonable opportunity, and what might be reasonable is going to be different from community to community. We would often say that you can limit it to 2 minutes or 5 minutes per owner, because what you don't want to do is be stuck there for 4 hours listening to owners complain about something. I would suggest you look at how city councils provide for public opportunity. Certainly the city of Seattle has very short time limits for each person to speak, and I think they limit the number of people that can speak, and they do it on a first come, first serve sign up. So there are some examples you could follow in terms of how open meetings and public comment are done, and adopting one of those is likely to meet the reasonableness standard. Okay. Valerie thought it was important for us to talk a little bit about the executive sessions. So you can't have a quote executive meeting because there is no such thing, and that would be excluding owners from a meeting. What you can have is an executive session as defined by the statute. You would have to have first an open meeting, which the owners are invited to, and then it requires a motion by a board member to go into an executive session for a specific purpose. And you have to state what the specific purpose is. What are you going to discuss in executive session? So if you're going to discuss delinquencies, you would do a motion to adjourn to an executive session to discuss delinquencies. And if that motion is passed, meaning the board has to vote on it, then you would excuse everybody and you would go into executive session. You cannot make motions in the executive session. So after you discuss the delinquencies, you come back into an open meeting where the owners are able to observe, and you would make the motions and vote on them so they're reflected in the meeting minutes. But pretty much, if you are trying to find any way of conducting a meeting where you don't invite the owners, whether you're going to call it a study session or an executive meeting or an exploratory meeting, basically all of those things, if the board is meeting, then the owners should be notified of the meeting and given an opportunity to attend, and they would need to be given an opportunity to comment. So anything you want to add on that, Jennifer?
I don't think so. So the next question, can an association suspend member voting rights for violations of the CCNRs? Currently, we're an old act HOA, our CCNRs allow that. Also, UCIOA currently says that voting rights of members cannot be suspended for delinquencies. But am I understanding correctly that the UCIOA for All bill no longer says that? Our CCNRs allow that too. So in general, We believe the intent of the legislature is to remove the ability for associations to suspend voting rights. And honestly, we have so many communities that can't get quorum and have not been able to achieve quorum for years. Why are you trying to suspend voting rights if you can't get people to vote? So this really doesn't make sense. We do not recommend that associations suspend voting rights for any reason. It makes it harder to reach quorum and pass any action for the community. Also, as a note, UCIOA was not amended in this bill to make UCIOA applicable to all. So the language of UCIOA for suspension of voting rights has not changed. If your declaration or CCNRs specifically states that the association has the authority to suspend voting rights, you can do that, but it has to be explicit in the declaration. If the declaration is silent, you don't have that authority. But also, your ability to do that will be limited because once January 1st of 2028 comes, that's going to go away. So just in general, this is a bad idea. We do not recommend our clients suspend an owner's voting rights for any reason. Ken, did you have anything to add to that?
Well, I will sort of add that, you know, our role as an attorney is to try and help boards accomplish, you know, their goals. And so if your documents do provide for suspension of voting rights, and there is a specific purpose you're trying to accomplish, you know, we do support what the documents will do, and we have advised clients that yes, they can strip voting rights from certain people. I had this come up recently at a meeting where an owner who was delinquent was not able to vote, and he had been assigned a number of proxies from other owners, and the management and board wanted to prohibit him from acting as a proxy. I didn't believe that that was possible under the governing documents because those were not his vote. Those were votes of other people, and they had the legal right to assign a proxy, and the proxy holder did not need to be an owner anyway. So we were willing to provide the legal authority to prohibit the owner from voting for himself, but we could not do what the board wanted, which was to prevent him voting for all the proxies that he had collected. So, you know, we do recognize, and this is, you know, when people ask questions, we recognize that there are facts and circumstances that differ from community to community and from particular circumstance to particular circumstance. And it is part of why it's challenging to give general answers. So I agree with Valerie that our general advice is don't try and strip people of their voting rights. We don't see a purpose. But that doesn't mean that we won't help an association when there is a specific purpose and the legal support for the action that they want to take. So that's part of why you may need to have an attorney assist you in making sure that what you're doing is also legal. So, did you want to add to that, Jennifer?
No.
Okay. Next question. I thought an HOA's right of first refusal only meant the HOA had first dibs on anything that comes up for sale. But then I read something different from the FHA.com and the National Association of Realtors website, that if the HOA has the authority to review any sale, that it's considered a right of first refusal. So they put a lot of other detail in here, which is not necessary to answer the question. The FHA has a broader prohibition on an association's right to review or approve a sale than just the right to purchase. So FHA does not like anything which requires board approval for a transfer of ownership or that could hinder the sale of property by requiring board review. So that's has become more and more something which FHA is doing. FHA last year decided that they did not want to allow any, quote, seasoning provisions which prohibited an owner from renting their home for any period of time following the purchase of their sale. So FHA changes their guidelines on a kind of regular basis, and they have become much less willing to tolerate anything which is a review by the board of the purchase and sale of a piece of property, a unit, or a lot. And so typically we see that these are stripped out of governing documents. We certainly strip them out when we do restatements, and we are occasionally asked to do a single purpose amendment to pull one out because an owner wants to get an FHA loan for a reverse mortgage, or they want to allow the homes to be eligible for FHA mortgages for new purchasers. Did you have anything to add to that, Jennifer?
Just briefly, if your documents do have a right of first refusal, our advice to our clients has been that you don't exercise that right. And part of that reason is because it can create liability for the association if a sale falls through. So if you have particular questions about provisions in your governing documents, please contact your association attorney. Did you want to add anything to that, Ken?
No, that was a good ad.
Okay, so next question. It's a presidential election year. RCW 6438034 is pretty specific that owners may place signs on their property. This suggests common areas and assets like roofs and siding of individual units, which the HOA maintains and replaces, are off limits. Is that correct? And the answer is not necessarily. It's not, the crux or what the legislature intended was to allow owners to put political signs in areas they have exclusive control. So it doesn't, if the owner has exclusive control over the unit or lot, and that includes siding, they can place a sign on their siding. It's generally not a good idea, but if they have exclusive control, they can do it. Except that also means the association can prohibit political signs in common areas or common elements, including the grounds and sides of buildings. It really depends on how the boundary of the unit is defined in your governing documents and where the owner has exclusive control. There is a caveat. Political speech such as Black Lives Matter banners, Ukraine flags, etc., may have a different analysis. If you have questions regarding that, contact your association attorney for guidance. Next part to this question, it's a multi-part. But what about limited common areas like decks, porches, and driveway ramps? This was kind of covered earlier. Owners may place political signs in areas they exercise exclusive control, including limited common areas, elements on their lots, units, etc. The association has the authority to make reasonable regulations or rules regarding placement, size, and number of signs and timing. If you need reasonable rules or want someone to review your rules, contact your association attorney. And then next part of this question, can you also offer helpful general guidelines and words of wisdom for boards of directors? So this is a very technical and delicate, I'm going to use that term, area to regulate. You need to make sure you're not regulating the content of the speech, only appearance, size, timing, placement, number. You can, and Gil brought this particular sign up a few years ago. Someone had put an F Trump sign on their lot. We believe language that is generally considered to be offensive can be regulated, but if it's a typical election sign, it should not be. So, regulating language is a little more risky, but if it's generally offensive, you're probably okay. Do not regulate messages or the candidate. So a general limit of one candidate sign is probably enforceable and it would be reasonable. This may also depend on the size of the lot, etc. You can prohibit someone from having 20 or 30 because that's generally unreasonable, but it really is a fact-specific and community-specific analysis. Contact your attorney. 2 by 2 feet, general size of a typical yard sign, that's going to be, that's probably okay. So the last part of this question, can the board restrict the timing and duration of the display? For example, within 90 days of an election, and signs must be removed within 24 hours following an election. So yeah, timing is something that the board can regulate as long as it's reasonable. You can do 90 to 100 days before the election. 30 days may also be reasonable. It depends on the community and size of the community. Removal within 24 hours may not be reasonable, but removal within 3 to 7 days probably is. It just as an overall, bad facts make bad law. Please do not be a test case. If you have questions regarding particular signs or particular regulations that you want to enact, contact your association attorney before you enact it to make sure that you're being reasonable and that this, whatever issue that the board wants to regulate is likely to be enforceable. Ken, did you have anything to add to that?
Just a clarification. When you said one sign, I think it's one sign per candidate. So I think you could prohibit an owner from putting 15 signs for Trump or Biden on their front yard. But I think you would have to allow a sign for a presidential candidate, a sign for the governor, a sign for Secretary of State. You know, I think that you'd probably have to allow one sign for each of the races which the owner is trying to support. And again, you're trying to regulate to preserve the sort of appearance and aesthetics of the community while still allowing them to exercise their First Amendment rights. The yard sign issue is one that actually went to I think to the U.S. Supreme Court. If not, I know it went to a state Supreme Court in one of the other states, where the courts ruled that it didn't matter that the Declaration had a recorded restriction on signs, that the First Amendment was overriding the Declaration and allowed for the political signs. So next question, can the community vote to make amendments to change their board of directors requirements? This would include the number of board members, terms, and qualifications. And the answer is, in almost all cases, yes, the community can do that. The specific answer may depend on the provisions of your governing documents, and the vote required to do the amendment is going to be contained in your governing documents. And under most of the statutes, the items have to be voted on by the community. There is a specific prohibition in the Condominium Act and in WUCIOA about a board alone setting the qualifications for board members. So that is to prevent a board from writing qualifications to keep other people off of the board. But the membership has the ability to set qualifications for board members, which might include ownership of a property within the community, might include living within the community or living within the state, might include that the owner has to be current on their assessments. So we've seen a number of qualifications which communities have adopted. So pretty much the answer is just yes. Anything to add, Jennifer?
No. Next question. With the presence of children on our private road, do we need to post a speed limit? If so, what should the speed be on a private roadway? 5 or 10 miles per hour? What liability does the condominium have in the event of an accident involving the children who live here? Do we have different obligations for renters versus owners' children? So just as an overall, excuse me, reasonable speed depends on the physical characteristics of your community. If you have specific questions regarding what speed limits can or should be placed, you need to contact your association attorney. But again, as a general rule, under 4661-400, this is actually the motor vehicle statutes. The maximum speed limit for city streets is 25. So an association with private roads may be able to set it lower, set the speed limit lower, but under RCW 4661-419, state and local authorities will not be able to enforce your lower speed limits. So if the association wants to enforce speed limits and potentially fine violators, and you have a speed limit set at lower than 25, you're going to have to do that. You can't call the police to enforce. So do you need to post a speed limit? If it's lower than 25, then yes. What liability does the condominium have in the event of an accident? Well, anyone can sue anyone for anything. So as long as the association is not aware of a condition that would make it unreasonably dangerous to pedestrians, it's not likely the association would have increased liability or liability for someone else's mistakes. So one of the things I really need to address here is the calling out of children. This may be a violation of the FHA, the Fair Housing Act, as age discrimination. If you have any rules stating children cannot play on the street or something like that, those generally are not enforceable because it's age discrimination. It's better to call out the activity that you're wanting to prohibit rather than the age or type of individual more likely to engage in it. So just be careful on how you word this. If there's safer areas to play, you can always suggest this, but make sure that if you have private roads or responsibility for bushes, trees along the street, make sure that the area is as clear as possible. Don't increase the little liability that you already have. So next part of this question, we have notified in writing the owner of our our concern regarding safety of children playing in the roadway, specifically near their unit, which is close to the traffic entry and exit points. What else should we be concerned with as relates to our condominium liability? That particular question invites legal advice. We cannot answer that, so contact your association attorney. Last part, if an accident involving one of the children occurs, would a driver be liable for obeying a posted speed limit? There are too many variables to answer this question. We cannot answer that. Liability would be determined both by the police who would investigate the collision and the insurance companies who would get involved. Drivers can be liable for reasons unrelated to speed, and the injured party may also be at fault, which could reduce the liability for the association and the driver. So in all, don't regulate age unless there is a specific health and safety reason to do so. And that particular regulation would need to be reviewed by your association attorney to make sure that you're not getting into something where you shouldn't be, or it creates more liability to the association. Ken, did you have anything to add to that?
Yeah, the other thing I would add is that you should be talking with your insurance agent also if you're concerned about liability and risk. You buy insurance, general liability insurance, and directors and officers liability insurance in order to help manage risk. So you're paying money to transfer the risk to the insurance company. And so they could help you decide what an appropriate amount of protection is. And if you have a particular risk feature like a road or a lake or a swimming pool, then you may want to buy more insurance because you may have increased risk. Some insurance companies will also do an inspection of your property to help identify risk areas. Of course, the downside of that is that they may identify a risk area you weren't aware of and want you to do something about it that is expensive before they would renew their insurance policy. So, for example, we've had a client where the insurance company was invited out and learned that the spacing on the handrails for all of their walkways, elevated walkways, did not comply with the building code, and small children could fall through the handrails. And so they required the association to install additional pickets to keep small children from falling through the handrails. And the client was not pleased with that result because they weren't expecting it. The next question is, in the same topic. If a water feature is on common interest property, does a sign need to be in view with regards to safety? I know we answered this question another day, but the short answer is that if a risk is obvious, it does not require a sign. Okay, so if you've got a lake or a fountain in the front of the building, those are obvious risks. There's no need to put a sign up. The reason you put signs up is because a risk is not obvious. So if you've got a hidden well or a drop off that is likely to cause someone to fall and be injured, those are occasions to put up signs. Otherwise, it's how obvious is the risk? And I would say that water features usually have high visibility and would not require a sign. If you had an undertow or something that's not visible, then put a sign up. And you could also talk to your insurance company about that as well. Anything else, Jennifer?
No. Next question. What can or should an HOA board do if their reports and or the board finds or confirms that some owners are not complying with the conditions of the association's master insurance policy? So this is inviting legal advice on the governing regarding this particular situation. You to fully answer the question, we would need the governing documents and a bunch of facts and probably the insurance policy as well. In general, if an owner is doing something that violates the conditions of insurance or terms of the insurance policy, they may also be violations of the governing documents or the rules. So you could enforce using your typical enforcement procedures if they are violations. If, however, the terms and conditions of the master insurance policy aren't already violations of your rules, you can add them. Depending on the type of community, you may have to give time notice for owners to review and comment on the rules, but you can always add conditions to your rules that comply with the master policy. What the insurance company wants may not be consistent with what your declarations require. The insurance company cannot create restrictions on use of the property, but the caveat is they can decline to insure for some types of losses. So you may be able to enforce on other grounds, you may not be. It really depends on your governing documents and what the owners are doing. You could try to educate the owners and get them to stop what they're doing. but it could, if you're not able to enforce and the owners continue, it could lead to your insurance being canceled. So there are too many specifics that we don't have to fully answer this question. But in general, if you can enforce due, if you can't, you may be able to add it to the rules, speak with your association attorney. But again, this really depends on the facts and circumstances of the specific issue. Ken, did you have anything to add?
Yeah, this question sort of really makes me want to know what are the specific circumstances and what is it that your insurance company is trying to require or prohibit that an owner's not doing. And then, as you said, does the association have the authority to actually impose a rule or regulation in order to get compliance with what the insurance company wants? I'll say the only example I could think of that might be good is that some insurance companies will prohibit use of barbecues. And it may or may not be within the association's authority to prohibit use of barbecues. And the association may or may not actually have done it if they have the authority. So the owner having a barbecue may or may not have any relationship to what the insurance company wants. Next question is, what does an association do if it is unable to secure an insurance policy? So I'm going to assume that this is a question related to a condominium and property insurance rather than general liability insurance for an HOA, for example. Almost every condominium declaration requires that the association buy insurance. And the statute for the Condominium Act requires that the association buy insurance for the property, at least covering 80% of the reconstruction cost of the building. And so if you are truly unable to buy insurance, then you are creating a substantial risk for your owners and the banks, which are using the property as security. And you should be notifying all the owners immediately of that risk and your inability to buy insurance. Okay. Normally, we don't actually see that it is impossible to buy insurance. What we see is substantial rate increases. I was just working last night on a memo for a community where their insurance was increased by about 8 times. So it went from in the $40,000 range to the $320,000 range. And my answer is you still need to buy insurance because the statute requires it and your governing documents require it. And the cost of insurance, even as high as it was still less than 1% of the value of the units and the reconstruction cost of the units. So it certainly looked ridiculously expensive, but it would still be much less than the risk which the owners would suffer if there were some kind of a catastrophic loss. So, other things I suppose you could do, and we recommend, one is amend your declarations to try and reduce the risk to the insurance company. If you increase your deductibles at the HOA level and you can shift that portion of the risk to individual owners for their units, then that lowers the cost of insurance. You can fix your buildings so they are lower risk. If you've got plumbing, which is past its useful life, and you've got leaks occurring on a regular basis, then you can replace the pipes so that you reduce the risk to the insurance company. We're seeing a lot of condominiums where the insurance companies are concerned because there are no fire sprinklers in the buildings. And the risk of a large loss is higher in a building without fire sprinklers. And so, you could certainly decide you're going to put fire sprinklers in the buildings. It would not be cheap. And most of our clients don't want to spend the money on replacing their plumbing or putting in fire sprinklers. But those are ways to make their building more attractive to the insurance industry to provide insurance to you. And it may be that your insurance professional can help you with finding additional ways to convince their insurance companies. You know, we've seen high-risk component amendments. We've seen associations that actually go in and replace components inside of units in order to reduce the risk, whether it's replacing water heaters or smoke alarms. You know, so there may be ways to work with it, because pretty much you have to find a way to get insurance. So, did you have anything else on that? Oh, the second part of the question. Do you have recommendations for budgeting and damage events such as water leaks and how they should be handled? My answer is that I recommend that you include in your annual budget the amount of the deductible which the association is going to have to pay if there is a loss. If you're experiencing on average more than one loss a year, then put in enough for your budget to cover all the deductibles you expect to have. The only exception to that would be if you happen to have an insurance reserve, which some associations do have. If the insurance reserve has enough money to buy the insurance next year and also pay the deductible under a claim, then I think you don't need to budget it separately. But otherwise, these are real expenses that most associations can anticipate paying, especially buildings that are 20 years or older. And I would include in the budget that you're going to have to do it. The worst that happens then is you get through a year with no claims and you have a surplus, which you can add to your reserves, which are probably underfunded. Anything else, Jennifer?
Not on that question. And then our last question in 3 minutes, which is doable. We live in an 8-unit condominium building. The building is 40 years old and will require some significant maintenance costs. At present, our reserve fund stands at around $6,000, well below our desired amount. The association plans to propose a special assessment to boost our reserve to at least $50,000. We anticipate resistance from half of the property owners. What circumstances would allow the president to enact a compulsory special assessment without requiring a vote? None. The answer is none. But the president alone cannot require a special assessment. 6490-525 requires ratification of a special assessment and every budget. So this particular provision is applicable to all communities. It's been applicable since July 1st of 2018. There is no way for the association to enact a special assessment or a budget without following the ratification procedures. So ways to get approval for this special assessment is to educate the owners on reasons behind the special assessment, and that having deferred maintenance will make it harder to sell units or get loans on the units. It can also, as Ken said earlier, lead to major insurance increases. But as long as a majority of the owners don't reject a budget or a special assessment, it's ratified. So if the majority rejects the special assessment, talk with them and see what they would like to see regarding the repairs. Try to find some sort of middle ground that gets you part of where you need to be, and then start increasing your budget to get you further in compliance with where you need to be. You can also hire an architect or engineer to inspect the building to see what repairs have to happen now and what can be put off a couple years for you to pad your budget to start budgeting for these expenses. You can also try to get a loan if you have the borrowing authority in your governing documents to get required repairs done and make it easier for owners to pay over time. And with 1 minute, Ken, did you have anything to add to that?
No, I'm good with that. So I think we're done for the day.
Have a good week, everyone.